decided, what she decided was, in this case, this bylaw was unconstitutional because people were going to be sleeping outside, and while they were sleeping outside, they needed to be able to protect themselves. It's not really very complicated. You know, this is really one of the first cases, if not the first case in Canada, to talk about the impact of laws on people who don't have any money, or who have very limited resources, or who are living in very, very difficult circumstances. And that's for a very, a reason that's no mystery. It's really hard to go to court. And if you don't have a place to sleep and you don't have a place to keep your stuff, how are you going to be able to conduct a lawsuit? So it's, one of the things we're going to talk about later is this may be the beginning of many more cases that will sort of thresh out exactly what exactly the Section 7 right is. But you can't expect people to have to take on too many of those cases. People just, it's not fair. So, I would expect that, I'm not speaking, entirely as a lawyer here, but when you ask your city councilors what they're going to do, they should do more than the Constitution requires them to do, right? I mean, the Constitution is a very blunt instrument. And we'll tell you what the case means, in our view, and we think it means a lot, but it doesn't by any means define what people should do, it just says what they have to do, right? And further cases will define other things that they have to do. You can only do so much at once, but don't let them get away with just that. So, I think we had a very good hearing from Madam Justice Ross. She listened to all of our evidence, and she paid a lot of attention to a great deal of background evidence, and Irene's already been through a lot of that. She listened to the evidence about the number of people who were without shelter here in Victoria, about the number of shelter beds, about some of the difficulties with the shelters, about the conditions that people face when they're on the street, because you hear a lot of stuff about crime and homelessness, but what you don't always hear is that homeless people are, more often than not, the victims of the crime, right? I think the statistics from Toronto or something like a homeless man is 9 times more likely to be murdered than somebody with accommodation. Something like 20% of homeless women in Toronto have been raped within the past year. And as Irene mentioned, one of the things about the tent city was that it provided a lot of safety, especially for the younger women who were there, who don't have very good opportunities for shelter spaces here in Victoria. So Madam Justice Ross listened to all that evidence. She listened to our expert evidence. Our expert evidence from Dr. Stephen Wang was that it was clear that in the climate we have in Victoria, if people were prevented from erecting shelter for themselves, and by that he meant some form of overhead shelter such as a tent or a tarp that's strung up, there will be serious and significant health consequences. Now, she didn't decide, the judge didn't decide whether or not people should sleep in public spaces outside. She found that in Victoria, people will be sleeping in public spaces outside. There's just simply no choice. Some people may choose to. For many people, there's no choice. Of the people who use shelters, the latest homeless needs survey, I think, said that 80% of them had been turned away from shelters, and the most common reason for being turned away was that the shelters were full. But she also recognized that there's problems with the shelters in some respects as well. So she didn't say people should sleep outside, she said people will sleep outside. And given that they don't have any choice whether or not to sleep outside, really the question before her was, when they're sleeping outside, should they be able to erect some form of shelter for themselves? Now, it's hard to see how she could have come to any different conclusion than she did. I mean, she looked at the city's reasons for saying they had to have this prohibition. And all the reasons that they said they didn't want to have people erecting shelter were really about not having people sleeping outside. right? It was all about, we don't really want homeless people around. But they're here. Homeless people are here. And given if you start from that proposition, the only question is, are they allowed to make themselves safe and secure and provide themselves with some measure of dignity and maybe even privacy? And that's what she addressed. So she made a finding of fact that there were significantly more homeless people in Victoria than there were spaces in the shelters. She made a finding of fact that the expert evidence had established that preventing people from erecting shelter would have serious and significant impacts on their health. And on the basis of those factual findings, she concluded that it was a breach of Section 7 of the Charter to prevent them from erecting shelter of some kind. Section 7 says that everyone has a right to life, liberty, and security of the person, and not to be deprived of those things except in accordance with the principles of fundamental justice. So when you're a Section 7 claimant, as we were in this case, we had to prove that there was a deprivation of either life or liberty or security of the person. And she found that there was a deprivation of all three in this case. She found that it was a deprivation of security of the person because it could cause you significant harm, deprivation of life because it deprived you of shelter, which was a necessity of life, and liberty because the choice of whether or not to protect yourself from the elements is a fundamental human choice that should be protected. And then she found it was not in accordance with the principle of fundamental justice. That was another thing we had to prove. So we had to prove the deprivation and not in accordance with the principles of fundamental justice. She found that it was overbroad and it was arbitrary because as long as people were going to be sleeping outside, you were still going to have damage to turf, you were still going to have, whatever problems the city outlined. Those mostly arose from a homeless population that had no place else to go, and I would add the lack of infrastructure to protect them. So a lot of the problems that they say arise from things like tent cities don't arise from the existence of the tent city. They arise from the fact that there's not proper facilities to support those tent cities.
So my question has to do with the provincial, the Attorney General's lawyers made this argument on a Wednesday, and I remember it well because the bailiff had to tell quite a few of us to wake up. Remember that? This was the one argument that was frightening, and it was repeated by Dean Fortin in the media just, I think, yesterday. And the argument is that it's not the place for the courts to tell our elected representatives how to obey human rights legislation. It's the responsibility of the electorate. And I've heard the term activist judge thrown at poor Madam Justice Ross, so I just wonder if you might address that.
One of the things that we said to the judge is, she doesn't have a lot of precedent because, all the reasons why we talked about before, that it's hard to get these matters before the courts when you're dealing with people who have very little money. And there just isn't any body of law that obviously addresses these things. So when somebody does something new, it's tends to be seen as activist. The Charter, the Constitution, is usually interpreted in the context of cases that are very often brought by corporate entities. And so the rights that end up getting litigated are a very different kind of rights than there are at issue here. So I think that when she recognized the very important dignity and security rights of people living on the street, she was doing something that hadn't been done before. And it did take people by surprise. It shouldn't have, but it did. And I think that's why people responded like that. We're just not used to having judges actually listen to homeless people.